Tomorrow's a big day. Tomorrow is the release of the Notifiable Data Breaches scheme. So the Privacy Act, 20 years old this year, which regulates how personal information is handled. Examples of things that are caught under the Privacy Act: name, signature, address, telephone number, date of birth, bank account details, medical records. As of tomorrow, there's a new scheme around, it's called a scheme. There's a new scheme around called the Notifiable Data Breaches scheme, which dictates what happens, what you need to do to respond to an eligible data breach. Now, from a payroll perspective, we think this is very important because of the nature of the data that we control and maintain from a privacy perspective. An eligible data breach is a data breach that is likely to result in serious harm to any individuals whose personal information is involved in the breach. It applies to any agencies and organisations, including would be us. The new legislation requires eligible entities to notify the AOIC of data breaches. So what is an eligible data breach? An eligible data breach is the unauthorised access to, disclosure of, or loss of personal information that an entity holds. If that information is likely to result in serious harm to one or more individuals, and the entity has not been able to prevent the likely risk of serious harm with remedial action. So if you lose payroll data that's going to cause serious harm, you need to report it. And you haven't been able to fix it, you need to report it. There's some nuances on this, and following this I'm going to talk about the European privacy rules that are coming out in May of this year as well. And there's a difference from the two in that the privacy rules in Australia, the definition of what is likely to cause serious harm is slanted more in favour of the employer than the European rules, which we'll see are slanted more in favour of the individual. So the definition of likely to result in serious harm, there's a couple of key words in there. First of all, the question of who determines whether the breach is likely to result in serious harm. It requires an objective assessment, so it's going to be subjective. The objective assessment is determined from the viewpoint of a reasonable person. Importantly, the reasonable person is the entity that controls the data. It isn't the individual. So the determination around whether the loss is going to cause serious harm is a determination that you make as the controller of the payroll data, not the individual. So as an example, we lose data, and we'll talk to how that might happen, and it is union dues, and the individual is unhappy because they think that's going to cause them concern. If you, in your judgment, determine that that is unlikely to cause serious harm, then you do not need to report that. So the responsibility for this rests, which is a good thing, with us. Likely to result. Likely to result in serious harm means it is probable that serious harm will occur rather than possible. So again, there's a limitation on this. It's not that this could possibly occur. It is that in your view, it is probable that serious harm could arise as a result of it. Serious harm includes serious physical, psychological, emotional, financial, reputational harm. So serious harm is a broad category, but I go back to the importance of this is that the decision around this process rests with the owner of the data. So what's some examples that could come through? So we sat down, we talked through from a payroll perspective, how do we think this could apply, and how would we respond to that when it did apply? Unfortunately, these are all real life examples. So mixing up the year-end payment summary for 2 employees. The question for you is that likely to create, is it probable that will create serious harm from a financial, personal, reputational perspective? And have you been able to remediate it? So getting it back quickly, etc. That my view, and I'm going to caveat all this because my view may not be your view. My view is that we could is that would be unlikely to cause serious harm, unless maybe it's the CEO that you give it to the janitor. Sending out one employee's pay statement to every employee in the company. It happened. That's a difficult one to remediate from. That's one where you look at that and think that there might be a risk of reputational damage, financial damage, etc., from the employee. So we had a client who worked on the year. This is just the worst nightmare. We had a client that worked on the year-end remuneration program, worked all the numbers out, did it through, finished at 11 o'clock at night, hit the button, and sent the spreadsheet out to every employee in the company. They then got the IT company, the IT people in, and they worked till 3 a.m. to recall the email. They took immediate remedial action to limit the damage. And on that basis, you might look at that and say that is something that isn't a notifiable data breach because they've remediated it immediately. This is the one that sticks for me. So we work from home, we work on our laptops, we have a USB stick, put the data on the USB stick, we lose the USB stick on the way back into the office. If that USB stick is not an encrypted USB stick, I think you've got all of the data, all the information. It is probable that there could be an impact on that, and you're struggling to remediate from that because you've lost the stick. So keeping your data on an encrypted USB stick would be a good example of how to take action before the event from that. I think if that occurred under these rules, that's one that I'd be thinking would be a data breach. So, and I think there could be other examples, and this is quite an interesting conversation. Again, I go back to it's a subjective test. So it will depend on the individual, it will depend on the circumstances, etc. Again, on the reasonable person perspective, that it is your position, it is your view that you take without having reference to all of the factors of the individual. So you don't need to go and work out whether that individual specifically would be affected because of something that is specific to their circumstances. It is a reasonable person would take that view based on the information that you know. So if you have a data breach, what do you do? Or what should you do? Contain the breach where possible. Take remedial action. If serious harm cannot be mitigated through remedial action, notify the individuals at risk that there's been a breach, and provide a statement to the Commissioner as soon as practicable. Lodge a notification with the Commissioner at the AIC website. Penalties at this stage are at the discretion of the Commissioner. And like STP, the Commissioner has said that they're going to work with entities for the first 12 months to ensure they understand the new requirements. So how should Payroll respond to the NDB scheme? As I said at the start of this, given the nature of the data that we manage on a daily basis, this is entirely relevant to us. Review and update your policies and your processes. Review your IT security systems. Use encrypted USB sticks as an example. And engage with third parties. There's some really good advisors I know that can help you with this stuff too. Okay, so that is the NDB scheme that came through. It comes through tomorrow. At the same time, there's a European scheme, the GDPR. So the General Data Protection Regulation rules have been in play in Europe, and they come into force on the 25th of May 2018. So why do I care? They apply to any business that holds, controls, or processes personal data of EU residents regardless of the business's location. So if you have expats that are into the UK or into the EU, not the UK anymore, into the EU and out of the EU, you are impacted by this. If you're a subsidiary of an overseas company, you are impacted by this. It is one of the most comprehensive pieces of privacy legislation deployed by any jurisdiction to date. And we've had privacy for 20 years, so we're well placed. It goes beyond the requirements of Australia's regulations. And I talked about NDB being more slanted towards the holder of the data. GDPR is more slanted towards the person affected. So, does it apply to Australian payrolls? Any Australian company that holds personal information of EU resident employees, businesses with EU subsidiaries, or employees seconded into Europe, businesses that operate global payroll operations. Outsourced payroll providers will need to consider the GDPR rules. And so you will see in the next 3 months, I would expect that you would see conversations happening with your outsourced payroll provider in relation to increased security from a GDPR perspective. So what's the difference between GDPR and the Privacy Act? First of all, there's no exemption for private sector employees. The Privacy Act has an exemption for companies with less than $3 million turnover. Under GDPR, there's no exception. Consent. So, there is a presumption under GDPR that an individual's consent has not been freely given where there's an imbalance of power between the individual and the data controller. What that means is, if you're an employee and you're given a 2-page privacy declaration and there's a tick the box section, you tick it, the GDPR, the commissioner, will take the view that because you're an employee and you just do what your employer tells you to do, that it's not informed consent. And so they'll expect that you will do more than just tick the box. There also needs to be transparent collection or privacy notices. So the GDPR imposes a stricter requirement of disclosure to employees before the collection of data. So what are they looking for? They're looking that the information that when you tell an employee that you're collecting information from a privacy perspective, you will let them know the categories of personal data collected, the intended purpose for the processing of that personal data, the legal basis for processing that personal data, the intended recipients of the personal data, the retention period of the data, and the employee's rights to request access to, correction, or deletion of the personal data. So you get a sense from that what we've been doing to date from our own privacy declarations may not be sufficient for what's there. So what are the employees' rights? The employees will have the rights to access, correct. Sorry, this is another distinction. Employees' rights are different. They'll have the rights to access, correct, erase, and restrict the processing of personal data, and they have the right to data portability. Wasn't quite sure what that meant. I'm still not quite sure what that meant, but we did a presentation. I was in a presentation yesterday, and they said that would include things like the Spotify playlist you've got on your computer. I think that goes a bit far, unless there's damage around what music you listen to. But there you go. The other difference between GDPR and the Privacy Act is increased protection around the collection of sensitive personal data, such as religion, biometric data, and trade union membership. You need to be clear on why you're collecting that data. You need to be clear as to why you're collecting that data. So, how might your payroll processes be affected? First of all, the basis for processing your employee data. If you're processing data inadvertently, which is not strictly necessary for the performance of payroll, this could count as a collection of non-essential data. Examples of that could be gender, union dues. Not sure at this stage as to where that's going to go. But we need to go back and revisit what is the reason as to why we're collecting the data. Security of your payroll information. Do your payroll processes meet the information security requirements of the GDPR? For example, meeting the timeframes for destruction of personal data. Do you have visibility over how your data is flowing through? Somebody asked a question, if we have a process where we are faxing our timesheets through and somebody else picks up off the fax machine, is that going to cause a problem? So I've got several questions. One is, why are you still faxing them? 2, why are you still doing manual timesheets? And 3, what information is on there that might cause an issue? And the information that we thought might be there maybe is the signature. So I'm not sure what's there. But thinking about the data flow and making sure that it is secure at all aspects. And then transferring data across border and understanding why. Okay, so what if I get it wrong? What does it do? So here's the penalties. The potential penalties for this are fines of up to €20 million or 4% of your global annual turnover, whichever is greater, just in case that wasn't big enough. And other risks, audits, compensation rights, class actions, etc. So I have a challenge with this in that the numbers are so large, you look at it and go, yeah, really, this is just not going to happen. We had a similar situation with the IRS when they were starting to look at the reporting of US citizens overseas that held foreign trusts and foreign companies, quite common in Australia. They needed to file these very complicated tax returns back into the IRS. No tax impact, but just file the forms. And if they didn't, the penalty was as high as 10% of the capital of the corpus of the trust. So the numbers were absurd for an information return. What happened over a period of time is the IRS started to pull those back to a much more reasonable number, but they started hitting really large penalties. So from an EU perspective for GDPR, I look at that and go, don't be ridiculous, that's never going to apply. But if it was €200,000, that would get my attention a lot more. What do we think is going to happen with this from a GDPR perspective in the EU? I don't know. It is entirely likely that the European Commission will want to make an example. Make an example of an organisation in the EU, make an example of an organisation outside of the EU to show that it fits. So whether you agree or disagree with the size of the penalties and whether you think they'll apply or not, because we're a long way away from Europe, this is something that we do need to be watching, because we do think that the EU is going to try to make a point on this in relation to who they attack, who they review from outside. So privacy is a big issue at the moment. Notifiable Data Scheme comes in tomorrow. GDPR, May 25th, 2018. We think this will have an impact on the way that you transport your data. There is lots of conversations happening at the moment with corporates. If you have not benefited from those conversations with your leadership team through to your payroll department, then your leadership team is missing a big part of risk, which is payroll.